He was recently awarded the 2019 Partnership Award by the PCMA Greater Philadelphia chapter. Mr. Grimes is one of the association and meeting industry's most prominent speakers. He has appeared before industry professionals throughout the United States and in Europe, the Middle East, Canada, and Mexico. Aside from his legal practice, Mr. Grimes proudly serves as an elected official as a commissioner in Lower Merion Township, Pennsylvania. Welcome, Mr. Grimes.
Thank you. Thanks, Sarah. Thanks to everyone at the chapter for having me present for you. It's nice to virtually see everybody. I hope to see everyone in person before too long, and I'm sure everyone probably feels the same way about seeing each other. Just a few ground rules or understandings of my own before we start. And I have to say, since most of you are in Pennsylvania, where I'm obviously admitted to the bar, I'm not giving legal advice today. I'm discussing educational topics. Certainly, if any of you need specific legal advice, I would suggest you contact a competent attorney of your choosing. The other thing is, as you probably know, after we run through a few of the initial questions, we're going to take your questions. And if you want to make sure you get your questions answered, I'm giving preference this morning to anyone who was wearing a Philadelphia Eagles sweatshirt or has an Eagles cup or something like that. So if you're wearing a Steelers outfit, well, maybe we'll get to you, maybe not. So having just lost half my audience, thanks for having me.
All right, thank you so much, Josh. So we will get started with some of the questions that were submitted prior to today's event. And then once we get through those, feel free to submit anything in the chat box. So Josh, the first question that we have is, in the cancellation and attrition clauses, shouldn't we be able to have to take into account the venue's lost profits rather than the entire room or food and beverage revenue? So we would never be responsible for 100% of the estimated revenue. This is if you cancel for any reason, not just COVID. I prefer it to be estimated profit, but I have not had success getting revenue changed to profit with any of the properties I've worked with.
Okay, so thanks. This is actually a really good question. And it's interesting that in the 3 months or so that I've been doing these webinars, the questions have been such that when I see a question just asking about lost profits and something not related to coronavirus, it's almost refreshing in a way, but this is a serious issue. The bottom line, I will tell you now, is that it's really the amount of revenue the meeting gets on cancellation, the venue gets on cancellation or attrition is what you negotiate. You can agree to pay as much as you want or as little as you want. But having said that, in general, we look at lost profits and the law looks at lost profits. And what do we mean there? So if a meeting cancels or if you don't use a room, there's some savings to the venue in that the venue doesn't have the cost of cleaning, doesn't have the cost of other services that you're providing for the group, and there's some savings. And so what the law would say is you take the gross room revenue, or suppose the room is $250 a night, you subtract out the costs of servicing that room, again, housekeeping, water, air conditioning, electricity, all those other things, and that's the net profits for the room is what would be most appropriate under the law. And their percentage we bandy about, people generally think 70% of the room rate, 80% of the room rate is customary for food and beverage. A maximum usually of 40% is what sort of is industry standard. Another thing I'll say is when you're figuring out these lost profit percentages, you should consider whether, if there's a resort fee, should that be considered as part before you take this percentage out? Should a mandatory service charge be considered? Generally, the answer is not, but what I've seen is some properties do ask for that in the contracts. And again, it's really what you negotiate. To the person who posed this question, you said you haven't had success in getting just lost profits with any of your properties. What I would suggest is a matter of negotiation. If that's not satisfactory to you, insist on it. And if they won't give it to you, then take your business elsewhere. But that's really the sort of the bottom line with any negotiating point.
Excellent, thank you.
Sure. Mhm.
Our next question is, we're all very anxious to get back to the business of meetings, as I'm sure you're aware. But
Yeah.
we don't want to put our employer and our client at risk. Is it possible to negotiate a contract with no damages for cancellation or attrition? So if COVID-19 continues to be a health threat or the economy is horrible, we can do a smaller meeting or cancel.
Yes. And, I could just stop right there, but lawyers can't do that. So I'll sort of explain. Let me just see, before I get to the legal part of this, some of you who look at meeting industry websites, so, MPIs, PCMAs, other groups, there are actually cities that are advertising right now that their hotels will do meetings with no cancellation fees and no attrition. And they're advertising that because they need business. So that's really the easy answer if you go to one of those towns where they're doing that. And I would be happy to give a plug to somewhere in Pennsylvania that's
Is it
doing that.
something
But
that,
sorry? Oh, okay, someone didn't mute themselves. I thought they were letting everyone know that their property is doing that. But that would be the easy answer. You can always ask for it as part of going somewhere else. And in fact, I see this happen a lot because look, let's face it, it's uncertain. None of us know, do we? If you're doing a meeting in November, December, January, whenever, we don't know what meetings are going to look like, or if there's going to be, we hope not, but if there's going to be a resumption of coronavirus, somewhere and all that. And some properties to get business are agreeing to allow an unlimited amount of attrition or even no cancellation fees. So bottom line is that's something to ask about. I suspect that with the economy having turned on a dime in the last few weeks, the last few months really, that you may get concessions from properties that you weren't going to get a few months ago. So you should always ask if that's what you want. Okay.
Excellent. As an independent planner, if somebody participates in my event, either as a vendor or as an attendee, and they catch COVID from somebody else who attended, what responsibility do I have? Do I need to start putting disclosures on ticket sales as well as participation, or have attendees sign a waiver stating that we are not liable if someone gets sick at our event?
Okay, so this is the million-dollar question right now that everybody is asking in every business. And before I give my answer, let me say that this is something where the answer could change. As some of you know, there's legislation that's been brought up in Washington and also in Harrisburg to shield businesses from liability from COVID-19 if you open up and follow the guidelines that the governor has set out. And now that, of course, is a big ask about following the guidelines. But so there could be legislation, but as of today, there isn't. So I'm going to answer that question with assuming no legislation. So there could be liability. There's problems of proof. What someone would have to prove in order to hold you as a planner or your client or the venue liable is they would have to demonstrate that someone caught COVID-19 at your event, which I think is a little difficult to prove, but with contact tracing and that sort of thing, or if many people who attended a particular event, a particular venue get it, that could be an indication that they might have gotten it. The other thing is that you must not have complied with your duty of care. Everyone remembers we talk about duty of care with liability. So I would argue that if you take precautions, you wrap every one of your attendees in a spacesuit and give them a shield and everything else that you saw poll workers wearing yesterday if you went to vote, and someone catches it anyway, you might not be liable because you did everything reasonable. But that's too easy, isn't it? It avoids the question. Because remember, in Pennsylvania and in any other state in this country, there's a difference between can you be sued and will you be held liable. So the can you be sued is yes, you can be sued. And people can sue anyone for just about anything. The question is, will you be eventually held liable? Although that's really part of the question, because if you're sued, even if you're not responsible eventually, it costs you money. You have to hire a lawyer, or your insurance company hires a lawyer if they cover it. And then you have the distraction of dealing with a court case. And then often these cases get settled, whether you're liable or not. So the point is, understand there's always the ability to be sued. So what do I suggest? First of all, put in your meeting contracts that someone, the planner, the venue, a third party is going to be responsible for health and safety measures related to COVID-19. Now, what health and safety measures? I would argue that the state, if you're in Pennsylvania, the state's standards are okay as a minimum. And in fact, the state standards here in Pennsylvania, frankly, are pretty conservative. So they're probably a really good start. Many of the hotel companies have their own protocols for health and safety. I think if you're meeting at a hotel where they have their own protocols, that ought to be a minimum standard as well. And then allocate liability by contract. So I'm meeting at, at the Marriott. Marriott is agreeing I'm paying for the meeting, so Marriott should agree to uphold their own standards that they've published for meetings and health and safety and COVID-19 circumstances, and any other standards that my group puts in the contract. So maybe your organization has your own standards. Put that in too. And then if they're the ones I'm paying to be responsible for compliance, if there's a mistake, like they don't follow all the rules, they should be responsible for any lawsuits or anything else out of being, that come from a lawsuit alleging that the standards weren't upheld. So that in general is a framework of what I think we're going to be looking at. And by the way, even more so, I think that we're going to see soon properties, and this is not a good or bad, I think it's just a fact of life. Properties have increased cost of complying with the health and safety standards that COVID-19 requires. So I think we're likely to see surcharges going forward for those increased standards, particularly if you're paying for their surcharges, even more reason to make the venues take that responsibility. Last thing I'll say is about disclosures and waivers. They're a good thing in general. Better not to have them, and seems to be what people are doing. They're saying, if you come to my meeting, you agree not to hold us responsible. Frankly, Disney is doing this. You go to Disney World, you have to agree by passing through the gates that you're not responsible, that they're not going to be responsible if you catch COVID from, at Disney. I think waivers are helpful, but there are limitations. They're not always upheld. But here's what you need to do to increase the chances they'll be upheld. Write them in plain English. In other words, don't have someone like me write them so someone can understand them. That was a joke, but I can see 50 of your faces and nobody's smiling, so forget it. All right. Make the disclosure conspicuous. So if you just say have terms and conditions for registering for our meeting, and you put them on the website, but someone doesn't necessarily have to see them before they click, I want to register, chances are that's not a knowing waiver and it might not be upheld. Should be given in advance. So we've got a meeting in Pittsburgh. I travel, in of course, assuming times are a little different right now, I get on a plane and I fly to Pittsburgh. And I get to the meeting at the Lawrence Convention Center, and then I see something saying, by coming here, you agree to not sue us for if you get COVID. Well, I've now gotten on the plane. I've paid the registration fee for the meeting. I've gotten on the plane. I've flown to Pittsburgh. Here I am. I've got a hotel reservation that's not refundable. So I don't really have a chance to back out at that point, do I? So what I'm trying to say is the more in advance you give people the waiver so they have the chance to consider it, the better. And finally, if you've got people under 18 attending your meeting, their parents or guardians should should waive for them, because it's not going to be effective for people under 18. So that's the long, short story on waivers. Okay.
Excellent. And I laughed at your joke. I'm totally
Thank you.
being, make you feel better. Um,
Thank you.
so the next question is, we have a conference scheduled for November that is still a go, although I'm sure it will look very different from the past in all sorts of ways. We will make sure that all safety protocols are in place for our group and the venue, but I am concerned that these protocols will require social distancing that will be too great so the venue cannot fit my attendees. And restrictions on networking activities at events and the hotel's bars will mean that our attendees cannot effectively network and get the benefits of an in-person attendance. How can I manage these concerns?
Okay. This has been like 2 of the last 3 months for me in figuring out for how meetings go forward for people in uncertainty. Let's face it. We don't know, as I said before, we don't know what's going to happen in November, do we? All of us, I think, hope that there's a vaccine or there's other measures in place or COVID goes away and we're not dealing with any of this. But we don't know. And some experts are saying that there could be a second wave at some point, which is why colleges and universities are trying to end their semesters earlier. So, and we're not going to know for some time, but what we know is we're dealing with uncertainty. So what I would suggest you do is consider what the experts are saying conditions may be in November. What's the worst that might happen? What's the less worse? Look at what the World Health Organization, the CDC are saying. I suspect the state has information on that. And also review the hotel health and safety protocols I've discussed earlier. Then have a conversation with your venues and ask them how they suggest handling it. Ask them to confirm if you have a 2,000 person meeting and the venue can barely fit 2,000 people in their largest meeting space under regular circumstances, ask them how they suggest you're going to handle it. And I think it's a fair question to ask that today, because I guarantee you're probably not the first person to ask that question, and it's business. They've thought about it. Review what sort of adaptations can work. So what I've seen some venues say is, okay, if this is still a problem in November, we don't have the room. If we have to social distance at 6 feet, we're not going to be able to accommodate you. But what we can do is we can take some of your people and we can put a hold on some space at the convention center. Or if we're in Harrisburg, maybe the farm show complex has some room that we can put people as a remote, in a worst case scenario, put people sort of as an overflow. And that may be an or at another hotel, frankly. They have some extra meeting space that we could put a hold on. That may work for you, in which case then your conversation is, well, who's going to pay for that extra meeting space? And that's another conversation. I mean, I would argue there's an argument that could be made that it's the venue's responsibility to find the space because they were supposed to accommodate your people, but that's really a conversation. The important things is that everyone has to agree that whatever the COVID standard is in November, that has to be followed. But then if none of that's possible, arguably it's a force majeure under your contract, but you're not likely to know that in November. It'd be much closer time before you could declare some sort of cancellation for force majeure. Okay.
Excellent, thank you.
Mm-hmm.
When I reached out to my insurance company, they told me I did not have anything to cover the loss of income or the loss of the business expense I've already paid. And they said that there's no insurance out there like that. Is there insurance that would cover COVID?
It's going to be hard to get. Some of you, if you had coverage for infectious diseases, then you might have been covered. But not the 95% of us that probably didn't, then you're not going to be covered. Although I will tell you that there's litigation going on around the country by businesses against insurance companies to require that your business coverage arguably does cover COVID-19. And in fact, attorneys general across the country are dealing with this as well. And I can't swear to it, but I believe the Pennsylvania Attorney General has also joined in that conversation as to whether businesses do need to cover it. If you went to the Attorney General's website, you could probably find that out for sure. Understand that infectious disease coverage, though, was not the norm, was hard to get, and I'm going to guess now will be virtually impossible to get going forward. And even if you can get it, it is not likely to cover COVID-19 because COVID-19 is already here and we know about it. So arguably the insurance company would be insuring a risk that's a certainty for them to have to pay out. What I would suggest you do is read your insurance coverage. It's not easy. It's sometimes painful to read those really long documents with all the riders, but read it. Make sure if you're told it's not that infectious disease is not covered, make sure that you agree in your policy that it's not covered. And if your coverage has been denied or you're not sure whether it's covered or not, consider consulting someone on the outside to see if there's other ways that maybe you can, maybe you want to join one of these lawsuits or pursue something on your own. And in terms of going forward, also shop around. If one person tells you that you can't get coverage, one agent, go to another one. I can't tell you what coverage is going to be like in a few months. I suspect that there's a price for anything, and there may be infectious disease coverage available going forward as long as you're willing to pay for it. And it's not going to be cheap, but so shop around.
Excellent. Next question. For clients who have booked meetings and signed contracts years out in advance, what's the best approach in adding language to existing contracts to more specifically address pandemic and major health issues like this? We want to be fair to the hotels while protecting our clients as well.
Okay, so first understand, we've learned some lessons with force majeure coverage in the last few months. I've learned lessons on this. What are those lessons I've learned? One is that to be sure that you can exercise a force majeure clause for cancellation in a situation like COVID-19, you must have in there, amongst the various unforeseen occurrences that trigger a force majeure, disease, pandemic, language like that. Because what courts say is that force majeure clauses are looked at very carefully, and if you don't include specifically things like diseases, that category, then it's not going to be included. Another thing that we need to look at is, when can you declare a force majeure? Most contracts have language that say, well, force majeure can be invoked if the unforeseen occurrence makes it illegal, impossible, or commercially impracticable, something like that, to hold the event. Well, when do you determine that? Generally, the last few months, properties have said, venues have said, and I don't know that I blame them, you have to look at the facts on the ground at the time of your meeting. So if your meeting is in June, we certainly know what's going on in June in Pennsylvania, and we can make a determination of whether it's a force majeure, or even more clear, in April, when we got to the middle of March, we knew that Pennsylvania was basically shutting down and you couldn't have group gatherings. So clearly it's a force majeure, but we don't know what it's going to be in November, do we? So if I were a venue or any supplier, I would say you have to wait until we're much closer, and then you rely on certainty. Is the state saying no group gatherings? No, they're not saying that, so maybe it's not a force majeure. I would argue that that doesn't make a lot of sense. And in particular, I'm not trying to be political, but look at what's going on with the Republican National Convention right now. Nobody wants to wait, and that convention is supposed to be in August. But the Republican National Committee is talking about moving it now because North Carolina, Charlotte, can't guarantee that they'll allow a full convention in August. Now, most of us, if we tried to do that, the venues would say it's too early to declare a force majeure, but that's exactly what they're trying to do in an uncertain situation. So I would look at that and say look, they've got all sorts of other influence that they can do what they want. But the point is that I think that's an error. And I think contracts in the meeting industry should make it clear that a group may want to, or frankly, or the venue may want to exercise this at a certain point in advance. Now, when? You might want to say the cutoff date in our room block. So the cutoff date typically a month before. If we don't have enough registrations, so it clearly is a force majeure, we can make that determination a month before, or maybe even 2 months before, and not have to wait till it's clear, like a few days before the event. That would be preferable to think about an advance date when you can make that decision. Another thing with force majeure clauses, we always talk about, and I understand until a few months ago, most people glossed over force majeure clauses. I mean, if I wasn't paid to read them, I might have also. But the other thing is that we see government regulation. You know, you can cancel if government regulation makes it impossible or commercially impractical to hold the meeting. Well, what is a government regulation exactly? Some people are now saying, look at the CDC. Well, the CDC doesn't issue government regulations. They issue recommendations and advisories. So arguably, that's not it. Or another example, you know, and this isn't with a meeting cancellation, but should you have to wear a mask? That's not an order. It's a strong recommendation in Pennsylvania. But the point is that wouldn't be, if it were something to prevent you from holding a meeting, wouldn't be good enough. So I think you should broaden your force majeure clause to cover government regulations, government recommendations, government advisories, and also which governments? Federal government, state government, local government, and maybe if you want to include the World Health Organization also, you might want to do that, but that's a separate body. The point is you have to be specific in terms of government organizations, which ones you're referring to and what exactly apply. And why do I say local? Because, for instance, right now, most of Pennsylvania is in at least the yellow, if not in the green. Philadelphia's in the red still, is supposed to go into yellow on Friday, but Mayor Kenny has suggested that he may not want to take Philadelphia out of the red on Friday, given what's been going on this last week. So that's why I say local government is sometimes different from the state. You need to include in all that. Moving on from that point, how do you deal with venues and contracts that you have now for an uncertain future? The first thing is talk to your partners in your meeting. Talk to your hotels, talk to your other venues, talk to your AV suppliers, talk to your transportation companies, and everybody else. You are not going to be the first one having this conversation. I guarantee you that. And so what you need to do is understand we're all in this boat together. Look, everyone's protecting their own interests, but we're all in this together and everyone has to get through it. So you may want a more flexible cancellation policy, right? That may work against the venue that may not want to give you a more flexible cancellation policy, but there may be things the venue wants. So for instance, I told you that hotels and suppliers are facing, I think, materially higher cleaning costs because of all the wipe down they have to do, the plexiglass shields, everything else they're having to do more in public areas. Maybe you agree to pay a surcharge for their cleaning that isn't in your contract, and arguably you may not have to pay it, but you might agree to pay it now in exchange for more flexible cancellation. Or you might agree to pay it in exchange for them giving you more meeting space than you needed originally, because now you have to deal with social distancing. So it's really a trade-off. Another part of negotiating is you may want to cancel a meeting, and you may have a terrific force majeure clause in your contract that will allow you to, but you may say, I'll go ahead if the property agrees to waive attrition, if we keep the meeting going ahead, but we're not going to get penalized for a smaller room block. So it's really a trade-off involved, and listening to what makes the other party happen. Look, I get paid to have sort of, I don't like to say it, but some lawyers win-lose situations. Our client wins, the other side loses. I would say this is a good situation where it's better if everybody wins. Obviously, at the end of the day, if it doesn't work, it doesn't work. But negotiation goes a long way here. So.
Excellent. And it looks like you also covered the answer to Christina's question that she put into the chat box about the force majeure. So we did get a couple additional questions that have come into the chat. So I'm going to go through a couple of those. Anyone?
Let me just stop you. While you're doing that, I have a landscaper outside my window, so I'm just going to shut the window. Excuse me.
Okay. All right, so if you have any questions for Josh for today, we still have about 20 minutes left. So feel free to type those into the chat box. I saw some have come into me privately and some have gone out to everyone. So we'll do our best to get through some of these. And if we can't get through all of the questions today, we will make sure that we are able to take those questions and use them for future information to get out to our members. So one question is, when the counties move into green, the current limit they're setting is 250 max. Does the maximum refer to the event specifically, or is that 250 people on the property?
I believe that the county means 250 per gathering. So if you have people in different spaces, then you can do more than 250. That would be my interpretation of it. So you can go ahead with the meeting as long as you disperse people into different areas.
Now, to take that a little bit deeper, if we have, say, a dinner for 250, but then you have to factor in the hotel staff that would be serving, especially considering we might not be able to do buffets, we would be doing plated meals, which means a lot more servers in the room, but that 250 include those people.
Wow, that's really a good question. I would think you could make an argument that 250 may not include the servers, but I'm thinking about this practically speaking. I would also say that there's sort of a rule of reason, and then there's well, what's going to happen if you make an honest mistake? My experience with this, and this is where I get in trouble, I suppose, but my experience is that the state is not sending out, or local governments are not sending out state police to enforce this. So I would suggest that servers that are not staying as part of it would be better to stay under the 250, including servers, but I don't think a property would get shut down for having servers on top of that. But that's just my sense of it. I think if that is a legitimate concern, I would suggest that that venues may want to ask the governor's office that very question, because that's actually a very good question.
Okay, great. Another question is, thinking about like guidelines and procedures that hotels would want to put out to try to attract planners and make their customers feel more at ease, is there somewhere they can go to get some suggested guidelines and procedures so that they can make sure that people can see that they're taking the proper precautions?
Well, a lot of the hotels are doing this already. Virtually every major hotel company has guidelines that they're putting into place, or procedures they're putting into place for how they're going to practice safety rules and health rules for COVID-19. Everything from plexiglass in the guest room registration area to wiping down all the elevator buttons every hour. For meetings specifically, I would look to whether they're proposing to follow guidelines. Now, I think I just saw this morning that GBTA, the Business Alliance, has put out some guidelines. I believe the World Health Organization has also put out guidelines for meetings. Um, and I would think that and the CDC has also. So I would think those are good objective sources, and a planner could take that and in advance of an in-person meeting or whatever, say to the venue where you're going to meet, here's the guidelines that GBTA has put in place. Are you meeting these? Can you tell me how you might comply with them? And then you'll get confidence with it. Now, I do think you need to do more than just say, you know, if someone says our hotel has procedures and look at our website, I would, as a planner, just like you do site visits for everything else, I would actually look and see if they're actually doing it. I am skeptical by nature because I'm a lawyer. Let's say we're glass half empty instead of glass half full. And I am skeptical as to whether every hotel is going to be able to implement their own procedures over the long term. You know, at 3 in the morning, are they really wiping the elevator buttons down every hour like their protocol says? So I think it's incumbent upon the planner to go take a visit and see what they're doing. But yeah, these are the, and every your organization may have your own guidelines too. I just would think about what it is makes you comfortable using the guidelines that the industry has put out, and ask the hotels to comply. One last thing, sort of a warning, although everyone can do what they want at the end of the day, when you're going to choose what guidelines to follow, I would make sure that they make sense to you. Some organizations have put out guidelines that look good, but they're really not. For instance, one hospitality organization has basically said, yes, we are enforcing 6-foot separation now, but we believe in 3 weeks it's going to be down to 3 feet. So that's all that we're going to do in 3 weeks. And in a few more weeks, it's going to be 2 feet. Well, that has no bearing right now in reality. So I wouldn't adopt those rules unless they really make sense. Okay.
Okay. Going back to the discussion about waivers, do you suggest that there needs to be an actual signed waiver if you decide to do that? Or can you put it out there, make sure it's out there early enough, post it everywhere on your site, on your event, put it on the registration form, but not actually require a signature?
I don't think it has to be signed in person because that's not the way most of you do your meeting registration anymore. Look, in a perfect world, would I like it to be signed personally? Sure. By hand, yeah, that'd be great, but that's not going to happen. If you use radio buttons on your registration, you could, on the website, you could have someone affirmatively have to check. I have read the rules, and including the waiver and assumption of risk. Or what I've seen some groups do is you can't register for the program. The registration button won't be active until you've actually scrolled through the waiver. So, and I think, some of the computer software companies do the same thing, frankly. You have to go to the bottom before you can check. So I think that's also a good idea. Understand that if someone gets sick at your meeting, or even forget about COVID for a second, if someone slips and falls at a meeting, if they're determined to sue you, they're going to sue you no matter how no matter how obvious your waiver was. There's never an absolute, but by making sure the waiver was knowing and written in plain English and giving in advance, it increases the chances it'll be upheld.
Okay, great. Going back to the force majeure, can suppliers contractually ask planners to make a decision 30, 60, or 90 days from the event dates? Or is that something that can be completely up to the supplier at the point given the force majeure?
Well, the short answer is yes. The longer answer is I wonder if that always makes sense. I can see why, because, you know, there's some sense that a supplier or venue may want to rebook, you know, or move on. But here's sort of the challenge. We may not know the situation um, 90 days in advance. So for instance, let me use an analogy to something we typically see in force majeure clauses, that if I had hair would make my hair stand on end, because I never know why people insist on this. Um, some of the, typically hotel contracts, they'll say if you want to cancel based on a force majeure, you must notify the hotel within 10 days of when the force majeure occurrence happens. We've all seen that. Sometimes it's 20 days. But the point is, if you have a reason to cancel force majeure, you have to tell the property within 10 days or you arguably waive the right to invoke it. But what's the problem with that? Okay, suppose I have a meeting we're now in June. Suppose I have a meeting in July. And under the current phase that those of you who are in yellow in, you can have a gathering of a certain size. But under green, you can have a much bigger gathering. If I have to cancel today, or within 10 days of when I know about the force majeure, I have to base it on the yellow warning today, because I don't know if Harrisburg is going to be in green in July or not, do I? Or the Poconos? I don't know. So why would you want to force me to cancel today if we could wait a little bit longer and then see what happens? And this doesn't, let's go back to the days before had COVID-19, if anyone can remember 3 months ago. This used to come up in situations with, suppose there's a hurricane, or there's civil unrest or what have you. So there's a hurricane in your meetings in Mexico, and there's a hurricane and the resorts are knocked out. And I've had this situation happen. A group has a meeting in 9 months, and a hurricane, and this happened a few years ago in Los Cabos, knocked out the airport, knocked out all the resorts. People couldn't travel there. Client had a meeting in Los Cabos 9 months from then. Well, their meeting contract said that if you want to cancel for a force majeure, you have to cancel within 10 days of the occurrence. So they had to cancel within 10 days of the hurricane. On the other hand, all the resorts in Los Cabos said, and the airport, we've got repairs going the day after the hurricane passed through. We're going to be back online in a month. Well, and in fact, they were. So the group could have had the meeting, but under the you must exercise this within 10 days deadline, they had no choice but to cancel. So in that case, the 10 days made absolutely no sense. So I would think long and hard about that sort of thing.
Okay. We have two people who have a very similar question, and both of them have meetings coming up here in September. So they're both kind of state government employees or county employees, and right now there are travel bans. So is a travel ban, whether it's a county travel ban or a state travel ban, is that going to be considered a government regulation? And would they be able to postpone due to impossible?
If you know the travel ban will be extended through the dates of your meeting, and it makes it impossible for most of your attendees, then I would argue that's a pretty good argument for cancellation. Now, but there's gray areas here. Suppose only 10% of your attendees are government employees, or even 25%. That doesn't make the meeting impossible, does it? Or suppose your meeting is you aren't government travel bans, but there are corporate travel bans. Many of us work with companies that have bans going on right now. Company travel bans generally are not force majeure because it's a business decision. It's not an unforeseen occurrence. If you have attendees who might be subject to a company travel ban, and let's not just talk about COVID-19, other things happen in this world. Civil unrest, all sorts of, I might argue that what's going on in many of our major cities in the last few days, would really be something we were talking about if we weren't all still talking about COVID-19. But those have their own issues. But I guess what I'm trying to say is, if you know your attendees might be subject to travel bans or travel restrictions, then you should negotiate something into your contract at the time you're signing the contract that says that if 25% of our attendees are subject to a travel restriction from their employer or something to that effect, then it can be a force majeure, that sort of thing. So you need to think about that. But if all your attendees are are government employees, that's clearly impossible. One other thing I should say, some of you may have heard about a concept called frustration of purpose. That is sort of an alternative force majeure reason, and it's difficult to invoke. But saying it really quick, frustration of purpose means the whole point of our meeting can't happen because of a force majeure, basically because of what happened. And that could include because no one can come because they have travel restrictions or our speakers can't come. If you want to be able to use frustration of purpose, you need to clearly set the purpose of the meeting in your contract. Maybe at the top, a line, here is the reason for our meeting, conference for XYZ. Attendees will be people from this industry. And then add words like frustration of purpose to your force majeure clause, and that gives you some added reasons to cancel if you need to.
Excellent. We also had another one, very similar, but not necessarily government employees, but talking about school districts and the fact that school district employees, and this is great because I work with school districts, so this would help me, but the school district employees are already looking at travel bans, budget restrictions, looking at professional development for the coming year, cuts in their budgets, and millions of dollars in deficits. Mm-hmm. Would that also be able to be filed under the force majeure, given that is the complete audience for the event? And the specific concern here is that a hotel is not allowing. Is this something that they should be trying to take further?
Well, I don't know that budget cuts at school districts are a force majeure. Force majeure is, and this is what I said at the top of this force majeure conversation. These clauses are difficult to invoke. And if something were to ever go to court, a judge looks long and hard and says, is it really a force majeure? So when we get into things like budget cuts, that doesn't really prevent the meeting from happening, does it? Frankly, the only reason I would say though, is that if the budget cut includes the school district absolutely saying no meetings, a school district is a government organization, and if they prohibited their employees from attending, well, maybe that is because it's a government decision that makes the meeting impossible. But if it just becomes inconvenient or difficult because of budget cuts, probably less so. Having said that, and again, I get disbarred for making conciliatory comments, but we're all friends here, right? So no one tell the Bar Association I'm about to say this. We're all in this together, right? And we all live here. We're somewhere in Pennsylvania, most of us do. The rest on the call wish they did, right? So, the hotels understand that it's a difficult situation, and I think that most of them want to work with people. On the other hand, understand what's happened to the hotel industry in the last few months. Revenue that everyone thought, look, we've been on a high in this industry for years. I mean, I've been around since the last recession, and from the looks of other people, maybe one or two of you did too, but the rest of you hopefully haven't been around that long. But there's waves of cycles, but in this particular one, hotels are a business. They can't give things away. If you have a contract, they can't just say forget about it because they've got employees also. And yeah, they got government programs and government grants and all that, as did some businesses, but still. What works here is maybe more flexibility on both ends. So I would say if you're having a tough time because you work for a school district and you've had budget cuts, talk to your hotels, your other suppliers. Maybe you can have a lesser meeting, defer the meeting for a year, and they'll transfer everything to the next year. See if there's a way to do it other than outright cancellation, because I think it'd be difficult to invoke a force majeure clause based on the way most of them are phrased. So, by the way, let me apologize to everyone. I realize that I've given really long answers today. This is what happens when you've been in the red zone for the last 3 months. So those of you who are in green and yellow, you see what happens when you don't get released into to yellow, at least. So, go ahead, sorry.
Nope, you are fine. So we're nearing up on our closing time here. So this is going to be our last question that we are going to have. Josh's contact information was scrolling during our beginning introduction there. We will also include it in the follow-up email with the evaluation for today's event. So please be sure that if you have specific questions, you can reach out to Josh directly. And then also, please stay on the line because we do have a giveaway that we would like to give to one random person that's attending today's event. So we'll get into details about that in just a second. But the last question that we're going to go with is, Josh, do you have any thoughts on the WHO's white paper suggesting we get confirmation from the government to hold a mass gathering? It does not seem to indicate what exactly a mass gathering is. Because they don't mention numbers, but do you have any thoughts on that?
I think the WHO's recommendations are just that, they're recommendations. First let me say specifically, I'm not aware of that specific thing, but just in general, it doesn't work everywhere. I can tell you when I step into my role as a township commissioner, which is, as was said at the end, that is sort of, it's supposed to be my other thing, but it seems to be my full-time job sometimes. But it is very difficult to get any crystal information out of the state for specific situations. Those of you who may have applied for exemptions from the essential business bans probably know that already. I would think it would be difficult to get the governor's office or the Department of Health to specifically rule for a specific meeting about whether it's permitted or not. Doesn't mean you shouldn't try if you feel that you need to, but I think that that's a guideline from World Health Organization. It's a nice idea, but I wouldn't get stuck. Like, I wouldn't say if we can't get specific approval from the Pennsylvania Department of Health, the meeting's canceled. I certainly wouldn't do that. Unless the Department of Health says absolutely you can't do the meeting. That's different, but somewhere no decision should not allow cancellation.
All right, excellent. Thank you very much, Josh. This was all really great information. If you look over to the chat box, you'll see so many people putting in their appreciation for today. They're voting for a part 2. So,
well, let me just say thank you to the chapter, to Middle Pennsylvania, and to others who've had me who are having me on this morning. I am doing a number of, probably one a week, for various industry organizations. So to the extent you found this helpful, I'd be happy to talk about other things if the chapter wanted, but you could probably find me elsewhere also doing similar presentations. But thanks again, everyone, and everyone stay safe and stay well.
Excellent, thank you so much. So we will close out the questions. The next thing that we have up for you is we have a giveaway. We were going to show you a Poconos video, but unfortunately, due to technology, which is just unreliable, we are not going to be able to show that at this moment. However, I am going to show you this fun, super fun wheel. Thank you to Brian Griffith for showing this to us. But we have our wheel of names, and we are going to pick a winner. We do have Christina Voss here with us. Christina, would you like to let us know what the prize is going to be?
Hi all. We are at SkyTop giving away a 2-night stay with breakfast for 2. So cheers and cross your fingers for a nice little leisure getaway.
All right. Our winner is, oh, geez, what is that? Melanie Bianco. That was so close. Melanie, are you on with us still? Uh-oh, Melanie might not be on. We're gonna have to go for another one. All right. Wendy Johnson.
Woohoo!
Yay, she's on. Congratulations. All right. Well, thank you everyone for joining us today. We truly, truly appreciate it. And thank you to our education committee for setting this up with Josh. They do a phenomenal job, and there will be more information forthcoming on what else we have planned for you this year. Sarah, do you have any closing remarks?
No, thank you, Kimber, and to the communications team as well for putting this on for us today. We really do appreciate your help and partnership. And Josh, just wonderful information. We may be speaking to you about a part 2 since it seems like we all are in the same boat and have a lot of questions. But thank you, everyone. Our next education event that we have scheduled right now is for July 1st, so save the date. We also have some great events going on within the chapter. So definitely check out our website for some more information. We hope to see you all again very soon.
Excellent. Thank you, Sarah. And most coming up super soon is next week, our next happy hour, which is going to be on June 11th. And then we have our brown bag event on June 16th. So we hope to see everybody at one of those 2 events. Thank you and have a great week.